Lesson 36, the Federal Court System. Article 3 established a national Supreme Court and gave Congress the power to establish lower federal courts. Here's Article 3, Section 1. The judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish. These words are on the face of the Supreme Court's marble building in Washington, D.C. Equal justice under law. The Supreme Court building, equal justice under law. The goal of our federal court system. Each state has its own laws and court system. Most U.S. court cases involve state laws and are tried in state courts. We're going to focus on the federal court system. Jurisdiction, a court's authority to hear and decide cases. Jurisdiction. The Constitution gives federal courts jurisdiction over 8 kinds of cases. 1. Any case involving the U.S. Constitution will be heard in a federal court. 2. Violations of federal laws, such things as kidnapping, counterfeiting, tax evasion. So any violation of a federal law will be heard in a federal court. 3. Disagreements between state governments. 4. Lawsuits between citizens of different states. For example, a citizen from North Carolina suing a citizen from Virginia, for example. So lawsuits between citizens of different states will be heard in a federal court. 5. Lawsuits involving the federal government. 6. Cases involving foreign governments and treaties. 7. Cases based on maritime laws or laws upon the seas, the waterways. 8. Cases involving U.S. diplomats. So, in these areas, the federal government has what is called exclusive jurisdiction, meaning the federal government, the federal courts, will decide these cases. Exclusive jurisdiction. In a few cases, state and federal courts have concurrent jurisdiction, meaning the case can be heard or tried in either the state or the federal court, because both courts have jurisdiction. We call that concurrent jurisdiction. How are federal courts organized? The U.S. District Court is the U.S. trial court at the federal level. It's where the trials are held, the lawsuits begin. We have 94 U.S. district courts in the United States. So if you are accused of committing a federal crime and you cannot plea bargain the case and it has to go to court, the case will be heard in a U.S. district court. It's a trial court. It has original jurisdiction. The authority to hear a case for the first time. Original jurisdiction. District courts have original jurisdiction in all federal cases. District courts are the only federal courts in which witnesses testify, juries hear cases, reach verdicts, evidence introduced, cross-examination. The only federal courts in which you have a trial setting. U.S. District Court. They hear both civil disputes and criminal disputes, or criminal cases in which federal laws are broken. A civil dispute is between two individuals, two parties involved in a lawsuit. Federal courts hear those type of cases as well. Every state has at least one U.S. District Court. We said there are 94 of them in the United States. Every state has at least one. North Carolina has 3 federal district courts. We have the Eastern District, the Middle District, and the Western District. So we have 3 U.S. federal district courts in North Carolina. The Eastern District of North Carolina serves 44 counties. Wake County is in the Eastern District. So, for example, you are a citizen of Wake County in North Carolina. You violate a federal law. That case will be heard in the Eastern District Court of North Carolina. The U.S. Court of Appeals has appellate jurisdiction. Appellate jurisdiction. The authority to review a case from a lower court. It's called appellate jurisdiction. The U.S. Courts of Appeal, they review decisions made in lower district courts. It's the first step in the appellate process. A panel of judges, usually 3 or more judges, review the case records. They listen to arguments from lawyers from both sides. Notice that U.S. Courts of Appeal do not decide the guilt or innocence or which side should win a lawsuit. They are simply reviewing the original trial. There are 13 U.S. Courts of Appeal in the United States, 11 of which are based upon geography. As you can see here, North Carolina is in the 4th Circuit, along with Virginia, West Virginia, South Carolina. The 4th Circuit Court of Appeal. Each of these U.S. Courts of Appeal covers a particular geographic area called a circuit. So another name for a U.S. Court of Appeal is a circuit court, a U.S. Circuit Court. So we're in the 4th Circuit, for example, the 4th U.S. Court of Appeal. There's one U.S. Court of Appeals for the District of Columbia, and then one U.S. Court of Appeals for the Federal Circuit. So we get 13 total U.S. Courts of Appeal. The United States Courts of Appeals are considered among the most influential, most powerful courts in the United States. Now, why is that? Their ability to set legal precedent in regions that cover millions of Americans. United States Courts of Appeal have strong influence on policy. Because the U.S. Supreme Court chooses to review less than 1% of the more than 10,000 cases filed with it annually, a United States Court of Appeal serves as the final arbiter on most federal cases. So when you get to the U.S. Court of Appeal, basically that's the end game. Very unlikely that case will go to the Supreme Court because of the great number of cases that are appealed to the Supreme Court each year. They agree to review less than 1%. The U.S. Court of Appeals, the appellate court here, the district court, the circuit court, they rule only on whether the original trial was fair and protected the person's rights. That's all they're doing. Was the original trial fair? Was the law properly administered by the judge in the district court? The panel of judges on a circuit court may decide in one of 3 ways: to uphold the original decision, to reverse the decision, or remand the case. In other words, send it back to the lower court to be tried again. One judge writes an opinion of the court. This is a detailed explanation behind the legal thinking behind the ruling of the circuit court. It will then serve as a precedent for future decisions. A precedent sets a standard for the ruling in all future similar cases. Precedents help make the law predictable, consistent, and fair. Of course, this is part of our common law tradition that we learned about in the very first unit of this course. Goes back to the English influences. Common law based upon precedent, rulings in court cases. Who works in the federal court system? Well, of course, we have judges nominated by the president, confirmed by the Senate. They serve for life. They can be removed through impeachment. There are more than 660 federal judges in our federal court system. Each district court has at least 2, and each circuit court has from 6 to 27 judges. So they have lifelong service once confirmed by the Senate, nominated by the president. Magistrate judges listen to evidence and decide if a case should go to trial, and they also set bail. These are federal magistrate judges. They set bail. U.S. attorneys, they prosecute people accused of breaking federal laws. They represent the United States in civil cases involving the government. There are 93 U.S. attorneys. Federal marshals arrest and transport prisoners, protect jurors, keep order in the court, serve subpoenas, ordering people to appear in court. The federal marshals. So here's our federal court system. Again, the trial court is the district court. The lowest level in the federal system, 94 judicial districts in 50 states and territories. They have no appellate jurisdiction. They have original jurisdiction. They hear the case for the first time. They try the case. And then above the district courts are the courts of appeal, the intermediate level in the federal system. There are 12 regional circuit courts, including D.C., and then, of course, the U.S. Federal Court of Appeal. Strictly appellate, meaning they have no original jurisdiction, these circuit courts. And then, of course, at the top of the federal court system is the Supreme Court. 9 justices. We will study the Supreme Court actually in our next lesson, so we'll stop right there. And this concludes lesson 36.